Rice.
Yes, Mr. Straight.
May it please the court, I proceed in this way, if I may. First, His Honour Judge Dyke, grounds of appeal. I'll just give references and invite the court to have in mind the character of the point. His Honour Judge Dyke, grounds of appeal, paragraph 67 of his judgment, page
Sorry, we say grounds of appeal.
and the grounds of appeal before His Honour Judge Dyke.
Oh, yes, okay.
Page 364, supplementary bundle, paragraph 67 of the judgment. Those grounds of appeal reveal grounds bearing upon a number of matters which were common to Vote Leave and Mr. Grimes, including section 122, where the character of the charge against both was exactly the same, namely that you put in more to your declaration of expenses than your expenses actually amounted to. You took a cautious approach. The Commission said that was illegal. His Honour Judge Dyke said no, that was wrong. And the same position obtains for us as for Mr. Grimes, but the report obviously continues to say both are guilty of that offence. Similarly, common plan, please see the evidence dealing with this, supplementary bundle 380 to 381. No common plan was identified by Sir James Eadie before His Honour Judge Dyke. No common plan has ever been identified. Please notice the definition of what is required for common plan, paragraph 22 of the relevant schedule in the European Union Referendum Act, page 78M of the bundle of authorities, legislative authorities, which definition requires, and please notice this in particular, that the plan must be one whereby expenses, referendum expenses, are to be incurred by A and B. A and B. And here, by definition, referendum expenses were incurred only by one party. Third, Freedom of Information Act, nothing to the point, cannot give power in any event exemptions, section 30 and section 32.
But your real point is, as you say, it's a bootstraps point.
Yeah,
If you haven't got power to do it, the fact that you say in your policy you're going to publish it doesn't get you anywhere.
absolutely.
Well,
Absolutely.
we'll hear whether Mr. Coppell
Yes.
wants to try and persuade us on that.
Point 4, electoral law. Please see De Beer and Begum in the bundle of authorities for the proposition that one does not go outside at all of the regulations. One sticks absolutely to them for the reasons given by Mr. Justice, I think he was at the time, Scott Baker, supported by the Court of Appeal, Sir Anthony Clark, Master of the Rolls, in the later case of Begum. 5, the various cases cited by Mr. Coppell. Notice, please, ex parte Taylor, which was a Director General Office of the Secretary of State, not a corporation. The Somerset case, in light of the Ingenious HMRC, was a breach of confidence case. It's not a comparator. So those are the points on those cases. As far as the point canvassed this morning and inadequately answered, I suspect, by me to your lordship, as
Sorry, do you mean any of the notices?
yes, I beg your pardon. Did I say report? Sorry. And please also notice, as far as when it came into existence as an unincorporated association, which, as you know, the Commission got entirely wrong. But the contrast can be seen in supplementary bundle pages 125 to 1 at 4.24, which actually refers to a different period, to a pre-issue period. To get that, you have to go to a different reference as well, which I'll give you. Other matters are concerned. Please see, in terms of prejudice, Mr. Grimes's witness statement, in particular paragraphs 30, section 145, if I can just add to the exchanges which occurred before the short amendment in relation to that. The excluded from 145, and a further reason why one wouldn't embrace that within 145 in terms of the monitoring and enforcement is the De Beer case and the Begum case. As soon as you start doing something which is individual to a particular candidate or party, you run the risk of being thought to this.
Okay. Can I just, on the back of that, ask you something that I was just thinking about more over the short adjournment? This is not the way Justice Swift reasoned it, certainly not primarily. But would it was incidental, not specifically to section 145, but incidental to the performance of the Commission's function?
Make a confession in connection with that. The confession is that on this side it had always seemed more likely it was going to be incidental to anything. It was going to be incidental to section 147 and function of schedule 19C, the notice, to publicise not the notice but a different thing altogether, the report. And the answer comes back as you ask that question of that thing. And there's a long way in which I would go in accepting that proposition, because as was accepted in the note, but what I don't accept, and where I say the line has to be drawn, is reporting what you have done, i.e. here is telling you that we have embarked upon this exercise and produced, in consequence of that, what we call our enforcement report, which deals with all four collectively, contains nothing by asking the question, what has happened after this Honourable Dyke ordered that the whole notice, as far as Mr. Grimes is concerned, to the small little introductory words drawing attention to the fact that he won his appeal. So it's a big contrast, my lord. So I go...
particular before the House of Commons.
Yes.
Suppose they did produce such a report in which they set out what they did by way of investigations and civil penalties. Would your submission notices?
No, my lord, I don't think I would, in that hypothesis, be answering the question in that way. If someone came and said, here is what has been reported to Parliament. Because the question which would then arise, set those out, the quantum of detail to be given would be such as to enable the document to be capable of understood by the audience to whom it's addressed. If you said too much, you might actually not be reporting what you were reporting because you get lost in the detail, some sort of paper chase. If you say too little, you're not reporting. But I wouldn't be saying that the position is one whereby one repeat the year is likely to embrace more than, if I can put it this way, one side of the equation. So you're not going to have this great apprehension. Hang on a moment, here we've only got one report like this. A point referable to how did all this start? And it started in consequence of it being suggested, core bundle 100. However, supplementary bundle, paragraph 2.6 on page 100, supplementary bundle, page cert, was new about veterans of Britain. They had had all along. So the prompt.
Where does this point get the actual ground of challenge? It may or may not be a valid point of which that would go. How does it go to the question of the vires of the Commission?
Well, there are two reasons.
To aid ex hypothesi a valid imposed ex hypothesi.
To the skeleton argument that was put in, and this provides the court with the relevant referencing as far as that is concerned. And second, because this touches upon an aspect if the basis upon which the Commission were proceeding, i.e. new knowledge from Veterans for Britain, was in fact not so, then plainly there's an aspect for the court to consider as to whether or not the matter should have proceeded.
And I don't understand that. Perfectly properly accepted that you can't challenge, you can't use this as a backdoor means of challenging the actual imposition of the penalty, because the reason for doing that is an appeal. So your challenge,
which initiated the report. And my Lord, I don't want, and as I say, I was putting this point here because I was closing what I thought was a point of detail otherwise left unfulfilled. And I don't want the matter which has been identified by my Lord Justice Singh in debate with me as the pure and simple varies point, which had something. I've done this.
You didn't do.
I'm so sorry if I didn't do this. And I'll also be an expense incurred by the donor. That's page 233, paragraphs 94 and 97 of the bundle of authorities. And the definition I've already given to the court.
another facet of the point you've already made by reference to His Honour Judge Dyte.
Yes.
It's saying that this decision was, we can now see with hindsight, although regrettably you didn't pursue your appeal, wrong in response. Yes, well, I think that's all you need to say, isn't it?
Then I've elaborated, and I've no desire to trespass on the court's patience. So, my lords, my lady, can I therefore, unless there's any other matter you would court wish to canvass with me, unless there's any other matter I'm reminded of at this stage, I hope I haven't trespassed much on your patience.
No, thank you very much, Mr. Straker. Yes, Mr. Coleman.
Can I, at the outset, deal with the point that was raised with me about the amendment to the answer is that no, it was, we didn't have a tracked change version. And we didn't note on the front of the report itself that this is version 2 or version 1. What I would say, if the court would pick up the supplementary bundle under tab 20, the point there is that the finding in relation to Mr. Grimes on that appeal was unique to him. It wasn't one which carried over to vote leave. The association as at the time at which it submitted its application to be a permitted participant. And that was why the Electoral Commission found Mr. Grimes had not complied. My mistake.
But these, you're quite right to deal with these points because they have been raised, but we're not really at the core of the argument.
That's not the core of the argument. The core of the argument, what Mr. Our position is that the Electoral Commission had ample power and ample vires to make and publish a report. and that there were no less than 4 suchly to inform the public of what it was doing through the publication of the report. Secondly, it also had express power under section 19 of the FOI Act to publish that report. And fourth, section 145 obligations that enabled it to publish the report.
Well, if you put it that way, if that's really the way you're putting it, 4 isn't separate because it's
incidental to the implied power. And I will take these one at a time, and as I said, respond. Sorry.
So it's rather an over-elaborate way of putting it. If it's incidental to an implied power, it's all ultimately got to be incidental to an express power, isn't it?
No, you can be incidental to an implied power as well, and that's apparent from the authorities.
It's your word, Mr. Cobble.
I'll take you to it in turn. So let's start with the...
Sorry, but Mr. Cole, before you begin, can I just ask you, what you call implied power, is that simply a paraphrase of paragraph 2 of Schedule 1?
Yes.
Right.
Complicated way of dealing with it. It's one which is consistent with the authorities. But let's just see, if I might, by starting with the implied power, where that takes us, and just so that you have the implied power on the part of the Electoral Commission to publish on its website the product of its work in the form of the notices. Mr. Straker, this morning, in response to questions from the bench, said, yes, the Electoral Commission could post up on its website the notices themselves, as the notices you see in the supplementary bundle at tab 14 and tab 15. And again, in response to questions from the bench, he said that a summary of those could be prepared.
Well, I'm not quite sure he did say that. I think he said that they could go up and a press release drawing attention to them could go up. I don't think he talked about a summary, though.
The notices themselves are addressed to the individuals concerned. If there is an implied / incidental power to do that, is there an implied incidental power to prepare and publish the report? And again, the report itself. And the court will have seen that we have just given examples, and they're only a small number, in paragraph 44 of our argument, to show how closely. The first thing that he pointed to was the fact that the notices identify that there is a right of appeal, but that the report does not. 10, starting at page 91. And bear in mind that this was published on the web. Had a hyperlink at the end to the enforcement policy. We see that at page 128. And the enforcement policy itself records the right of appeal, and the court will see that under tab 1, where there is the enforcement policy, one of the supplementary bundle, and it's recorded at 8.14 that the recipient may appeal to a county court in Scotland, to the sheriff, against the decision to impose variable monetary penalty and the period of time within which such an appeal was noted. So, in the way of publication on the web, you go through the various links, and that information itself was available to the public that was minded to read all of the report, that there was a right of appeal. And really, what it came down to, the case for both leave, is that there are bits of the report to which it takes exception. It's not the vires of the report itself, actually, which is being challenged here. The fact of making a report what the complaint as it emerged today really is that there are bits in there to which the learned friend side take exception.
Mr. Coppola, I'm not sure it's entirely fair of the way Mr. Straker answered some of my questions, at least. He made it very clear that his fundamental submission of law is the simple one, that even if the report was entirely accurate and they had no objection to any of its contents, that there is simply no statutory power to make or publish it.
Well, I well remember your lordship asking the learned friend that question and the response received to it. One gets that answer and one tries to put it side by side with his other answer to the questions from my Lord Justice Underhill, that they had power to publish the notices themselves on the website, and we're left totally puzzled as to why one is lawful and the other 100%
Well,
accurate.
that's a perfectly good point in itself, which you've to some extent made, and may not feel you need to develop, but it doesn't answer my lord's point, which is that you're attributing to Mr. Straker an argument that he, speak for myself, didn't advance. I think it's fair to say from time to time he wanted to make us, to let us know what his clients didn't like about the report, in respects in which they said it was defective. But he made it perfectly clear that that was not of the essence of his legal submission. The most it was illustrative of the sort of mess you can get into and the problems that can be caused if the report is defective. But that's all secondary. The main point is that there's no power to issue it, good or bad. And that's, I think, where the focus of your submission should be.
Well, yes, my Lord, I quite accept that, but once you have the answer to your lordship's question to my learned friend as to whether the Electoral Commission could publish the notices on its website, Singh's questions, could they publish any report 100% accurate, 100% based on the notices? Answer no. And we say there's a logical inconsistency in those two positions.
I have that point, certainly, yes.
And that's, you are, and so that's our basic point in relation to it. It is correct that whether you characterise it as an implied power or an incidental power, if there is a detailed statutory scheme covering the publication of particular information, and we'll look at the way that was reasoned out in the baby products case, but we're not here concerned with that. There were and there are various provisions that require the Electoral Commission to make annual reports, generally in relation to the manner in which a referendum or election has been carried out in the preceding 12. So that's the first point we make in relation to the incidental power. And it's also correct, and one can see from the cases to which we've made reference, that where, for example, confidentiality is breached or personal of that Act, the 1987 Act, with enforcing various safety provisions. Under section 14.1, prohibiting a person from supplying or offering goods for sale, and then there was a right of appeal to a magistrate's court against a suspension with compensation rights. Then the various statutory provisions were considered by Lord Bingham in his judgment, starting at page 173. But what's important, and particularly important in this survey, are the passages starting at 175 letter E down to the foot of page 176. What he identifies there are three separate powers. First of all, on page 175, the issue of a suspension notice under section 14. and that is conferred both on the Secretary of State and on the local authority. Then over the page we see there's a prohibition notice, and that is conferred on the Secretary of State but not on the local authority. And then at letter E on page 176 there are warning notices, and again that's solely on the Secretary of State and not on the local authority. And at this point over the page at 177, the passage to which my learned friend took to court, the learned Chief Justice says it's apparent from these provisions that they comprise a detailed and very carefully crafted code designed to achieve the objectives. So you've got some powers that are with both the local authority and Secretary of State, but there are other powers, the prohibition notice and the warning notice, that are confined to the Secretary of State, and that's why we seek to issue such a warning. What happened in that case was that Liverpool City Council didn't issue a suspension notice. What it did instead was to issue a press release, and it records there that the local authority had asked the producers to stop supplying the products. And the claim that was brought against the local authority was that they had no power to issue that notice as such. The challenge was upheld, but the reasoning is critical, and it comes from the concession to which Mr. Straker referred, 178, just under the letter B. Mr. Fordham accepted that, speaking generally, it was open to local authorities to publish information relating to their activities, at any rate within their areas. Had the council issued a suspension notice in accordance with section 14, that fact could, he accepted, have been announced to the public. Pausing here and relating that to the Electoral Commission. The Electoral Commission undoubtedly could issue these notices. That's not in issue. And we would say, just as Mr. Fordham rightly conceded in the baby products case, that the council, had they issued the suspension notice, could have announced it to the public. So too, we say we could announce what we had done, as we did through the report, of the issuing of the notice. And just to pick up on the point which I was questioned about a little bit earlier on, Chief Justice said, had the council initiated any criminal proceedings? That fact, in section 111, that's the incidental power of the Local Government Act, gave authority to make such announcements if statutory authority was needed. So,
well, with great respect to the Lord Chief Justice, he obviously didn't have in mind the kind of discussion that we've been having.
no,
It's a passing comment. I mean, it's absolutely fundamental to public law in this country that a statutory corporation has no always required. Then it becomes a question of statutory construction, whether its powers are express or they arise by necessary implications.
and that's the point about the baby products case, is that there was a statutory code, and so the issuing of a press release by Liverpool City Council, when you analyse that code, served to get around them. But we are not here in this case. Just to pick up that Taylor case to which the Lord Chief Justice referred to, it's under tab 12 and of the authorities bundle. It concerned the Office of the Director General of Fair Trading, which is an office established by the 1973 Act, and the office is a creation of statute. And what had happened was that the company Taylor had earlier been convicted of a number of breaches of statutory provisions, in particular the Consumer Protection Act of 1961, and relying on a statutory power, section 34 of the 1973 Act, the Director General had sought a written assurance from the company that it would desist from that sort of conduct. Now, after giving the written assurance, the Director General then set out or sent the company, Taylor, a copy of a proposed press release setting out the convictions and the terms of the assurance that the Director General had been given. And the company and its director sought a declaration that the Director General had no such power. And we see that on the second page, 293, at letters D to E. And there was no such express power on the Director General to publish, but the claim was dismissed. And the key proposition, which comes out from the judgment of Lord Justice Donaldson for present purposes of 294, between the letters C to D, where he records, the Director General needs no statutory authority to speak and write about his work and about misdeeds of others with which he is concerned in his work. Both the Director General and his office have full freedom of speech, subject to the law of defamation and to any special statutory restrictions. And whether the court chooses to characterise this as being an implied power or part of the incidental powers, it's neither here nor there. What it is a general statement that where you have a statutory office holder, in this case, a statutory body in our case, which is accountable to the public, it needs no express statutory statement.
Well, he doesn't say express, but is what you are, in fact, how you are glossing it, which may well be right, is what he really meant was the Director General needs no express statutory authority.
Yes, that needs to be, I would suggest, read in, because there was no such express.
The only other way of reading it, which I think would first looks as though he may be saying, but I agree with you, I don't think he really is saying, is, well, because he's an individual, anyone can say anything.
No, I don't.
But it's clear he must have been thinking about him as an office holder, speaking qua office holder.
Bearing in mind the way in which the challenge had been made in the first place, that has to be correct.
Quite. So, in that case, in order to be reconcilable with the general proposition my Lord put you earlier, Lord Justice Donaldson,
And I would pick which my learned friend referred to was is the Kennedy judgment of the Supreme Court, which is under tab 20.
to be fair, he only referred to it because he thought you were going to. It's not fine by
That was a
himself.
complaint. But it's the detail of it needn't concern us. But what does come out from this is, again, echoing the words of Lord Justice Donaldson, that of a public authority having an implied power to say what it is doing. Now, this case, which is quite detailed, was a FOI case in which a journalist, Mr. Kennedy, a journalist for the Times newspaper, made a request for information of the Charity Commission, so a body which owes its existence to statute, as it was constituted then, which was under the Charities Act 1993, now repealed. But the essential facts and conclusions were, first of all, we had a public authority, the Charity Commission, creature of statute, and one of its functions was to conduct inquiries into charities, and it had conducted 3 inquiries into a charity founded by Mr. George Galloway called the Mariam Appeal. And following these inquiries and relying on its statutory powers, the Charity Commission had prepared and published 2 brief reports. Mr. Kennedy, the investigative journalist for the Times, wasn't satisfied with the information coming out from these reports. So what he did was he made an FOI request of the Charity Commission in order to get the underlying documents. The Charity Commission relied on an exemption to that right, which destroys that. So, pausing here, at this point, Mr. Kennedy had no statutory entitlement to receive this documentation. But what the court went on to say is, well, nevertheless, the Charity Commission could give Mr. Kennedy that information under no duty to do so, exhausted its power under inquiries. And the reasoning of the Supreme Court is important. And just to pick up the opening paragraphs of the speech of Lord Mance, which is in the report of judgment at page 488 in our volumes at 527. Lord Mance opens his speech by indicating that information is the key to sound decision making, to accountability and development, underpins democracy, and assists in combating poverty, oppression, corruption, prejudice and inefficiency, and so on and so forth. And he then carries on in this vein, paragraphs 1 to 3. And if we go to paragraph 49 of his speech,
Judgment, I think.
which is at page, the large page numbers at the bottom, 544. And he says, here Mr. Kennedy has shown that important questions arise from inquiries and reports relating not only to the subject matter and outcome.
Judgments on it.
I'm sorry, judgment.
Yep.
Page 567. Paragraphs 128 to 129. And in particular, paragraph 129, where Lord Toulson says the power of disclosure of information about a statutory inquiry by the responsible public authority must be exercised in the public interest. It's not, therefore, necessary to look for a particular statutory requirement of disclosure. Rather, the question in any particular case is whether there is good reason for not allowing public access to information which would provide enlightenment about the process of inquiry and reasons for the outcome of the inquiry. And my lady and my lords, that is, again, similar to what we say mandates the report that was published here.
Is it really? I mean, it's not a function of the Charity Commission to give this information. Responding to a request and the question whether they ought to respond to that request is a fundamentally different kind of question from the question of whether it is within their powers, in the sense that we've been looking at, to issue a report. It's a different kind of situation, isn't it?
It's different in the sense, my lord, I would accept that in one case it's a volunteering by the body, whereas in Mr. Kennedy's case he made the request. And it's no different in the sense that Mr. Kennedy had no right under the FOI Act to any of this information. So the question left with the Supreme Court was, if he has no right, can they simply say no to it and leave it at that? And what they're saying is, no, you cannot. In effect, it goes further than that. You may not wish to, but because you are a public body, because there are duties of transparency, you should be providing this information to him unless you can show that there's confidentiality or overriding public interest. It shouldn't be going out. Now, whether the Charity Commission wished to do it in response to a request by giving it out, though being under no obligation to do so, or indeed no express power to do so, or whether a body such as the Electoral Commission volunteer it to show the public what they have been doing to enforce the rules and regulations relating to an Electoral Commission, is for the purpose of vires, we say no different. So, what we say, pulling this all together, is that we did have the Electoral Commission an implied power, we would say is its logical home, as a body to tell the public how it was we were going about our enforcement functions, what we were doing and what we had done.
It is one way of putting this, I don't know, but ultimately, if I'm right, that the fundamental doctrine of our public law is that there has to be some statutory power. But that's a question of statutory construction, and as we all know, that does not necessarily require express words, because on its true construction, a statute may in fact confer a power because that's implied. Is what you're really submitting that public law has now reached the point, see Kennedy, where one of the aids to statutory construction, and an important aid to statutory construction, is that the context is one in which we are dealing with a public authority discharging functions in the public interest. There it was statutory inquiry. Here it's investigation into a matter of public importance to a democracy.
Certainly.
And the imposition of civil penalties on people. And that therefore one should, is this right? What you're saying is that one should construe the statute having regard to the important public interests in openness and the public knowing about these things.
Exactly, Lord. And indeed the previous case before this court is illustrative of that. As your lordship and your ladyship will remember distinctly from that, the complaint made against the Electoral Commission was that we weren't doing enough. We weren't investigating. And there it was, the complaint being made against the Electoral Commission, in the sense the reverse of what's here being said is, listen, Electoral Commission, you are not doing your job. And what one draws from that is that certainly in relation to this referendum, and indeed in, one can anticipate were there to be others, there is a huge public importance in knowing that the regulator is regulating, that the regulator is enforcing, and knowing what it is that it is doing. And that earlier case bore witness to that. So, yes, it is an implied power. It's an implied power when you stand back and look at the conspectus of provisions which govern the Electoral Commission. It is a public body on a matter of acute sensitivities, and I'm not going to disagree with Mr. Straker in relation to that. Acute sensitivity, but part of it, coming with that, is an accountability to the public about what it is that it is doing, how it's going about it, and what it has done. And the issue here is not on the part of Mr. Straker and his clients, not the manner in which it has been done, the particular content of the report. It is that we cannot actually publish the report, advising the public of the notices that have been issued. And we say that that is simply incorrect. Can I then turn to section 100?
My lady had a point.
I'm sorry.
No, it's simply taking it a step on from the point you're making, because one of the grounds upon which objection is taken is that there were 4 notices, and what you have is a composite whole in the report. Would the reasoning be thus that in something like this, which is of importance and sensitivity, where there is a linkage between the 4 notices, it makes sense, frankly no more than that, to publish it as a whole?
Well, that's certainly what we would say, and your ladyship will have seen, as we point out in our skeleton, there is a close relationship between the content. In fact, some might say that it's just been copied and pasted from what is in the notices to what is in the report itself. And it is a composite of an investigation relating to more than one individual. In relation to some individuals, it went no further. It's only right that the Electoral Commission indicate we considered the following 4 individuals in relation to two of them, we thought it was sufficient to go ahead and publish a notice. But just as right to say that in relation to the other two individuals, we didn't reach that conclusion. So it's not just a question of those that you go against, it's also the ones that you've investigated and said, well, it falls short. And again, Mr. Straker's posture is that there is no power to do this, leaving the public uninformed of the ones that we have investigated but not issued a notice. Because embedded in his submission is that if you don't issue a notice, you can't prepare a report to say, we investigated and we found that there was no basis for issuing a notice. And that, we say, is fundamentally wrong. It is part and parcel of our functions, the Electoral Commission's functions, to let the public know when we have investigated what the outcome of that is, whether it's the issuing of a notice or whether saying it falls short of issuing a notice. And with that, I do then move to the express power, that's the section 145 provision. And just to indicate paragraphs in our skeleton in which we deal with it, that is paragraphs 66 down to 73. And section 145 we have already looked at in bundle A, the legislation bundle, under tab 7. And the submission made to vote lead is that this didn't constitute monitoring compliance. One of the explanations given for that position is that in paragraph A, of subparagraph A, there's no reference to section 147. If we look at the way that the provision is worded, you'll see it's the restrictions and other requirements imposed by or by virtue of, and it's part 7, which are the provisions of the 2000 Act dealing with referendums. That's sections 101 to 129. And the, quote, restrictions and other requirements are restrictions and requirements imposed by those provisions. Section 147, which gives life to Schedule 19C, are concerned with the sanctions or sanctions procedure for contravention of restrictions and requirements. And you see that in terms in section, in Schedule 19C, that's under tab 12. And it's like page 59. If you turn to the section dealing with discretionary requirements, paragraph 5, reads, the Commission may impose one or more discretionary requirements on a person if satisfied beyond reasonable doubt that the person has A, committed a prescribed offence under this Act, or B, has, otherwise than by committing an offence, contravened a prescribed restriction or requirement imposed by or by virtue of this Act. So that takes it back to part 7 for the, when dealing with a referendum, takes it back to part 7. It's part 7 that prescribe restrictions and requirements for the purposes of a referendum. And what Schedule 19C is concerned with is the civil sanctions for non-compliance. And so when we go back to section 145 under tab 7, the Commission monitors compliance and secures compliance with the restrictions and other requirements by the procedure the sanctions procedure in Schedule 19C.
Yes, I don't quite see how it monitors compliance by the sanctions procedure in 19C.
It-
I think I see how it takes reasonable steps to secure compliance with it. It's a little bit awkward because the natural meaning of taking reasonable steps to secure compliance is to see that compliance happens. If you come along later and say, after the whole thing's over, there wasn't compliance, does that fit naturally within the concept of taking reasonable steps to secure compliance?
Well, yes is my short answer to that, but in relation to what your Lordship has just said, certainly the fact of reporting on what you have done on a past occasion in relation to contravening a restriction or requirement secures the compliance hereafter, because it is a matter of securing compliance to show what it is that you have done in the past for people who contravene. And that's the flaw in Malone and Friends' submission by saying, well, you just concentrate on the referendum period and the period during which the obligations arise, and after that it all falls away.
That's one point. I think that's really the point that Mr. Justice Swift made, if I understood him in his judgment. He was looking to the future, at least in part, in construing the phrase reasonable steps to secure. Can I take you back, if I may, for a moment to the word monitor? And I just wonder whether that has to be contemporaneous. Because you may not know. There may not even be any way of knowing at the time. It may only be once the returns have come in, once investigations have done. At that point, it may be possible to say, we have now monitored whether there was compliance during the referendum period.
Yes, so
But there wasn't. Well, there was.
Well, precisely. The referendum period is a defined term, and it comes to an end on a particular date. And at the end of that date, there are various reporting requirements and what have you, and again, they are all in-stopped under the terms of Part 7 of the Act.
Yeah. So in this context, for example, the referendum period ended by statute on the 23rd of June,
Correct.
2016. So the very day when votes were cast is actually the final day of the referendum period. So if I may have misunderstood the submission by Mr. Straker, but if he's right, then you can't be monitoring compliance after that date.
Well, that's as I understood the submission as well, and of course it neuters Section 145 in terms of its efficacy, because things might, and indeed almost certainly will, come out after the end of the referendum period, which go to compliance with the restrictions and other requirements of Part 7 of the Act. And the idea that the Electoral Commission must be blinkered and not taken into account completely empties Section 145 of its efficacy. It can't be right.
We did say, if I remember correctly, my lady will, I think, remember as well, in the Good Law Project case, I think we did suggest that this statutory regime really has to be construed in a common sense way.
Well, I'm not going to quarrel with that, and it is important in securing compliance. The monitoring is the first task to securing compliance, and then taking steps thereafter. And things will come out after the end of the referendum period that relate to compliance with the restrictions and other requirements of Part 7. And the Commission, we say, must always be alive to those, and then take such measures, such steps, as it considers appropriate to enforce them. the scheme just does not work otherwise. So,
So would you say, in fact, that the duty in section 1451 is necessary to make one four six and 147 work, because otherwise all those do is set out schedules which give powers. One, the power to investigate. Two, the power to impose civil sanctions. But there must be some provision which requires them to exercise those powers in an appropriate case. Otherwise, they're given powers, but they're not put under a duty in relation to them. And do you say 1451 is, as it were, the motor for 146 and 147?
Section 145 is the motor for the provisions in 146 and 147. But what we say is that that motor isn't switched off at the end of the referendum.
Quite, but I was just really thinking it out. You do go that far, and perhaps it helps you to go that far, that 146 and 147 wouldn't work without a 145.
Well, they wouldn't work, and they don't work if 145 is switched off at the end of the referendum period. You might well, or the Commission might well, pick up certain things during the referendum period that enable them to go and exercise the powers in Schedule 19B and 19C. But they are bound to be curtailed, and indeed severely curtailed, if come the end of the referendum period, that, to use your Lordship's word, that motor is switched off. So, my Lady and my Lords, just looking at section 145, we say that the compliance is obviously compliance by those that are actually involved in the referendum process, the 120 odd permitted participants in relation to the 2016 referendum. And it also looks forward to other referendums that may be conducted in the future. And we remember that Part 7 of this Act, indeed this whole Act, doesn't mandate particular referendums. You find the mandate in a specific piece of legislation, in this case the 2015 Act, in relation to the alternative vote, the 2011 Act. They mandate the particular referendum. And these provisions, Part 7, governing how the permitted participants are to behave during that process, apply to all of them, the past, the ones that have been conducted, and in the future. And the Electoral Commission secures compliance by letting people know how it will go about its enforcement procedures, that it will enforce, that it won't overlook, it will investigate, and where necessary, it will impose penalties. And that, Lady and Lords, the indication of what it does and how it will go about it is a perfectly reasonable step to secure compliance with the restrictions that are in the 2000 Act. Those restrictions are alive at all times, and as soon as a particular Act mandates a particular referendum, the two engage. So that's our first express power, we say, in relation to it. The other power, if recourse were needed, is to be found under the publication scheme, which the Electoral Commission, like all public authorities, is required to have. And the relevant provisions are in tab 26 of the bundle of statutory authorities. Publication scheme is dealt with in section 19, which we see at page 182. we see there is the duty of every public authority, which the Electoral Commission is one, to adopt and maintain...
Sorry, which section?
Sorry, 19, page 182.
Yes, thank you.
It's the duty of every public authority, it's the duty of the Electoral Commission to adopt and maintain a scheme which relates to the publication of information by the authority as approved by the Commissioner, called the publication scheme, and they have a publication scheme. And then B, to publish information in accordance with its publication scheme. So there's a duty to publish in accordance with the publication scheme. And then we see some specificity is given in subsection 2 to the content of the publication scheme. If we then go in the supplementary bundle to the witness statement of Ms. Lardner, that's at tab 28. She gives in her witness statement an account of the publication scheme, and as is generally the way with most publication schemes, it is published on the website of a particular public authority. And if your ladyship and lordship turn to page 405, that's the larger numbers, you'll see the Electoral Commission, our publication scheme, and there are a series of hyperlinks which are underlined. But at 406, it says one of the areas that it will publish is what our priorities are and how we're doing. And then the last of the subheadings there is enforcement, action and sanctions. And then that hyperlinks to which you'll see at page 442. Sorry, it hyperlinks to page 439, where you'll see our enforcement work. And then at the first punch hole in 439, you'll see one of them is in this section, investigations, with a little arrow key. And then that takes the reader to page 442. And we see there...
Sorry, I've got lost. Where's the link? Where's it on 439? Where am I looking?
Adjacent to the first punch hole, my lord, you'll see the word in this section, investigations, a little arrow.
On 439, that means so.
There may be two 439s. I think the wrong page was included in the first. It should be coloured like this.
No, I haven't got that. Sorry.
Hang on.
Are we being told that this was submitted to the court and just reached us, or?
I understand it was.
Well, perhaps it doesn't matter too much. I just wanted to follow the check.
The lone friend I can see has got something
No.
in colour.
I think there's been a debate about it, and we have resisted any additions to the bundles on the basis that the evidence had been, so to speak, closed.
Oh, really?
Well, can I just, notwithstanding the resistance, just show how the page...
No, I object, my lord.
Well,
We've had this debate.
I'm sorry, it is for Mr. Straker to object if he wishes. Mr. Straker, do you object? What?
Well, my lord, I confess that I'm not quite following where this point goes. We've made the observation that the bundles and evidence is now closed and it ought not to go. But I'm not going to say any more, and if the court wishes to look at these documents...
Well, it seems to us sensible to see it, de Beniesse. I haven't at the moment understood what the problem is. If simply a wrong document was put in, that sort of thing is always sensibly corrected between the parties. If it's some wholly new evidence, then possibly there's a problem. But let's see it first, and then we'll...
This is the document.
Yes. just to point, it's, if your ladyship and lordship see, it says in this section, and then investigations as well.
Yes, I see. Well, no, but what I'm very reluctant to spend a lot of time on this, but since the point has been raised about it, I better understand it. The text of this, looking briefly, looks very similar, although the page is shorter. But is it an earlier edition, or is one a hard copy and the other printed off the internet? And if so, why are they different? What's the point?
I don't understand how the difference has arisen. What I do know from those instructing me is that the version that I've just handed up is the one that makes and made at the relevant time the link.
Yes, I see.
As you drill.
Why was it not then copied to Miss? I'm sorry, I forgot her name. Is it Lardner's witness statement?
I don't.
So, okay, the position we're in is you are saying the wrong document was exhibited, and you're, I think, apologising.
I apologise.
But you want to show us what the right document was.
It does. It's a
right.
step in the chain. It isn't actually the end point that
No, I understand that. Mr. Straker, it's extremely unlikely anything will turn on this, but do you maintain any objection?
I'm not maintaining any objection.
That's very helpful, if I may say so, Sanson.
I'm very
Right.
grateful, my own friend. So that then.
But it doesn't look. Can we just learn a lesson from this? This is not the first time that exhibits to Miss Lardner's witness statement have been shown to be wrong. Don't think sufficient care was used in putting that witness statement
sure
and its
that's
exhibits
been
together.
noted.
I hope that has been noted.
Of course.
Right.
We then turn to where that link takes the reader. It's to page 442.
Yep.
In the usual fashion, sort of drill down, and there you see in this section, leave.uu group, vote leave, Mr. Darren Grimes. So it's that top entry in the middle column that links to the report itself. So this is, as we say, the publication scheme, and basically.
Well, that's not really the publication scheme. That is showing something that has been published. Am I?
No.
I thought the publication scheme says this is the kind of thing we publish.
Correct.
Then from time to time you do publish things in accordance with that scheme.
You're required to publish in accordance with your scheme.
Well, all right,
That's
you may be required to, but the point is that you do it. But the scheme is what you were showing us before, isn't it?
The scheme is the top. The
scheme is the design or the framework or the.
But also all what's underneath it, and you ask yourself, what we're doing is, are we publishing the report under the scheme?
I don't understand that, I'm afraid, Mr. Colpole. The publication scheme, with capital P capital S, by statute, has to be approved by the Information Commissioner.
Only in its generality.
Well, that is the generality. The scheme is the generality.
That's what I mean.
Correct.
Yes, so it must be possible to identify, put our hands on, literally, a document which has been approved by the Information Commissioner, because that's the document to which the statutory duty to publish, in accordance with, attaches.
And that is the document that is before the court.
Page 405. Is it?
And the page is higher up. So if you're.
Well, that's the bit I'm not understanding. It's my fault, I'm afraid. If I were the Information Commissioner, I would want to know, with 100% accuracy, what is it that I am being asked to approve, and what is it, therefore, when I do approve it, will go out there into the world, so everyone will then know exactly what it is that they have a duty to comply with. Because otherwise, there's a risk. If you start having hyperlinks and documents under documents and so on, I know electronically that's all very straightforward these days, but the Information Commissioner won't necessarily know that I've approved that at all.
Well, the way it works is if you look at Ms. Lardner's witness statement, starting at page 396, So you'll see at paragraph 5, she says that it is taken from the Information Commissioner's model publication scheme, and that is a permissible way of going about publication schemes, so that the Information Commissioner isn't required to traipse through thousands and thousands of publication schemes. She issues model publication schemes, and if a public authority models its publication scheme on what she has provided, then that is compliant.
So I'm still not making myself entirely clear. It's really the same question that my Lord put to you, I think. Where is the document which is actually the publication scheme? Not other documents that are published in accordance with that scheme, but the scheme itself.
Well, that, my Lord, starts at page 405.
Yes.
Well, does it? Let's just see. 405 is where's the text referring to it?
I'm sorry, my Lord, the text in the witness statement.
Yes.
That is paragraph 3 of Ms. Lardner's witness
No, I
statement.
think it's paragraph 12, isn't it?
Oh, sorry.
Wait a moment. This is oh no.
Paragraph 4.
AL2. Yes, I see. It's paragraph 4. Yes, I see. Thank you.
So, it says, this is our publication scheme. And they say that they have adopted the Information Commissioner's model publication scheme and follows the definition document for non-departmental public bodies. And then rather than having something which is...
Well, perhaps I can just say, perhaps the additional document you showed us shouldn't have been a part of AL2, because AL2 is the scheme. It doesn't have all the documents published under it. So maybe Ms. Lardner was right in what she exhibited. Anyway, we can't know. But the one thing that can't be part of the scheme is the hyperlink to a document published under the scheme, because the two are conceptually complete distinct things.
Well,
It's like having a bookshelf, which is empty, and this shelf is for this, and this shelf is for that. That is the scheme. You may then put books on it, but the whole thing isn't the scheme. It's simply you have populated the bookshelf in accordance with the scheme.
on this web page, as indeed on many web pages, it could have been done that all of the text for the hyperlinks could have been put on a single page, and you would have had a page that involved scrolling down and down and down and down.
Yes.
That's not generally the way things are published on the web. What one does tend to do is to put the hyperlinks as
That all makes perfectly good sense, but the point would be just the same if you had copied lots of pages with lots of documents under each heading. The point would still be the same. The scheme would be the thing without the particular publications under it.
Oh, my lord, absolutely.
Right.
And
Well, perhaps we're arguing about, perhaps we're at cross purposes, but I think that's the only point that my lord and I were making.
I'm
But it does have a practical consequence, because there was a danger of the way you were putting it, saying we're obliged to publish this because we have published it.
No, we're obliged to publish it because of
Because the
section
scheme-
19(1)(b).
The scheme says, you say, that if you say under your scheme you will publish a particular class of document, you're then under a duty to publish it.
Correct.
Yes.
And this was within.
Can we then get to the real point here, which is that cannot be right, because that is a complete bootstraps argument. Suppose there is, to make it easy for us and difficult for you, an express statutory prohibition on publishing certain sorts of document, and you publish a scheme, one of the headings under which is wide enough to cover that kind of document. That doesn't give you an obligation, a power, still less an obligation, to publish the document which your primary statute doesn't give you the power to do.
No, because of that would be excluded information. So the public, for the very reason your lordship has indicated, you do not publish in the publication scheme things that you are proscribed from publishing, whether by statutory obligation, duties of confidentiality, and what have you. So
Yes, but that still makes the point that the scheme of the Freedom of Information Act can never confer a power, still less an obligation, but doesn't really matter, confer a power to publish something which your governing statute does not give you the power to do.
no, my lord, with respect, no.
Really?
Correct.
Well, you're going to
It
have
is
to not persuade.
imposing a freestanding obligation on public authorities, and the whole object of it is to encourage an openness which had been perceived not previously to be so apparent in public bodies, to publish information about themselves, not to override proscriptions, whether express or implied.
Okay, we'll put my example, maybe a bad example for that reason. But where is the... I see nothing in what you've shown us so far in the Freedom of Information Act that that confers a power to publish information that you would not otherwise have a power to do.
Oh, my lord, it's section 19.
You
The
say
only
the
other way of
obliga-
reading section 19 is to read it down.
you say the obligation necessarily includes the power.
Of course.
And this is
You're under-
statute.
If section, with greatest respect, my lord, if section 19 would be read in your lordship's way, then publication schemes would have far from the amount of information that public authorities for the last 15 years have been publishing about
Why?
themselves.
Because I see nothing surprising in all the information that's been published under these provisions being something they had the power to do anyway under their governing statute. Because it's incidental to their functions.
Commissioner publishes model publication schemes which a model publication scheme which doesn't take its steer from trying to find a way through all of the different constitutive statutes for the public authorities to which it applies. It simply says you have a freestanding duty under section 19 to have a publication scheme. This is a model publication scheme which, if you adhere to, you are meeting your duty under section 19 to have a publication scheme. Now you must publish information in accordance with that publication scheme, section 19(1)(b). It's not necessary to found the power anywhere else.
So we can agree that if there is some other legal prohibition, so breach of the Official Secrets Act, common law principles or equitable principles of confidentiality, defamation, so if there's actually some legal wrong which would be committed by publishing, you accept there is neither a duty nor a power then to publish, even if otherwise it would be in accordance with your publication scheme. But you go on to make the submission that even if you can't locate the origin of the power to publish in any other statutory foundation, the Freedom of Information Act now provides that foundation.
So if you look at the constitutive statute for the British Potato Council, which is a public authority under the Freedom of Information Act, know nothing about publishing information about itself. It is obliged, and indeed it complies with its obligation under the Freedom of Information Act, to tell the public about itself, what it does, how it does it, what it's been doing, and it gets that power. And the only source of that power is section 19, unless you were to find it in its implied power existence about what the public want to know about the British Potato Council.
Well, That's what I was putting to you. It doesn't matter to you on which basis you win, but
Yes.
it only matters in a case in which you can't conscientiously say there is any power in the constitutive statute. Then you can say, well, it doesn't matter because it's conferred by Section 19. And it may be that in practice it's very difficult to think of a case where you can't find such a power in the constitutive statute.
Certainly, given the indications
Given its all
given by the
implication
Supreme
anyway,
Court in
yes.
Kennedy.
Well, it may be that we're arguing about nothing. Once you've got rid of my difficult example where it's prohibited, which I see you have.
So that's our second express source of power. But possibly returning to where I start in relation to the incidental power, which is in the schedule. And this we deal with, my lady and my lords, at paragraphs 83 to 86 of our skeleton. And as Mr. Straker has correctly noted, the Electoral Commission does have an incidental power, which is in paragraph 2 of Schedule 1, to do anything other than borrow money, which is calculated to facilitate or is incidental or conducive to the carrying out of any of their functions. And we would say that that is their functions, whether expressed functions or implied functions. And
Is there any authority for that proposition? Because what
Yes,
Mr. Straker submitted, that you can't have something which is incidental to the incidental.
you can't have anything that is incidental to the incidental, but you can have something which is incidental to the implied.
I see.
And if your ladyship and lordship look at the bundle of authorities, it's the Allsop decision, which started in the divisional court and then went up to the Court of Appeal, which is under tab 14. And that was a case concerning the breadth of the incidental power under local government act, that's section 111. The local authority, relying on that power, offered certain of its employees voluntary redundancy payments that were beyond those that were mandated by then the equivalent of the Employment Act that we've now got, or indeed the Superannuation Act. And whenever there's a provision involving payment of money, there are special considerations that are at play. But if your ladyship and lordship would pick up at the foot of, it's in the print of 366, the report is 479, so we're in the Queen's Bench division. And we see that the relevant words of section 111, that's the incidental power, include a reference to the delegated legislation made under the powers conferred by sections 7 and 24 of the Superannuation Act. And then one goes over the page.
Sorry, where was?
I'm sorry,
Where
we
was
should
that
now
last
be-
bit you were reading?
The foot of 366.
Oh, yes,
the
I've got-
large 366.
Yeah, I have it now. Yeah, thank you.
And then over the page at 367, at the foot of that page, as to functions, and remember the incidental power is incidental to functions. As to functions, we agree, having regard to Hazel and Hammersmith and to the other authorities to which we've been referred, that the functions of a local authority should be construed broadly, and see Moffat and Eden District Council, that the functions include the acts which such an authority is expressly or impliedly authorised to perform. We also accept that as a function of a council, as a local authority, to maintain good staff relations. proposed to avoid industrial strife, to provide services and to dismiss staff, as Mr. Gowdy contended. All these conclusions flow from the cases to which we were referred when reviewing Mr. Gowdy's argument. But as we have indicated, we do not accept that Section 111, it's the incidental power, empowers the local authority to pay money under an enhanced voluntary redundant scheme to promote those ends, i.e. the express or implied ends. And then the other provisions, the only other provision is the authority, Hazel and Hammersmith, which my learned friend
Sorry,
referred.
did the Court of Appeal say anything about this point?
It's touched on.
Because obviously, if the Court of Appeal has decided the point, then it's binding on us.
Yes, Lordship says the Court of Appeal starts at 370, and they reach the conclusion that the power isn't to be found expressly or impliedly, and then go on at foot of 373 to ask the question, well, is it to be found in Section 111, the incidental power, coupled with the functions in Part 9 of that's the Superannuation Act 1972, to conclude that it isn't. And then you will see at 491, towards the top of the page.
Sorry, just before we get there, it's the first time I've seen this, so forgive me if this is a false lead. At the bottom of 486, there's reference to Mr. Howell's argument that Section 111 only allowed for powers ancillary to an express function. So that is the point we've been looking at, isn't it? And then, is it Lord Justice McCallum, whoever it is, Lord Justice Parker says, I regret to say I do not follow this at all. That appears to be a rejection of that submission,
It's
isn't
a
it?
rejection of Mr. Howell's submission.
Well, am I missing it? Isn't that the point isn't that the point
yeah.
you need, or not quite?
That is the point that I need, i.e. he's saying you've got express, you've got implied, and Mr. Howell was saying, well, you can only have incidental to express, which is similar to Mr. Straker, and that's been rejected.
So, right, so where were you about to take us?
Well, just the concluding paragraph judgment where he says, I would accordingly come to the same conclusion as the divisional court. It might be said, well, that's just a conclusion rather than reasoning. But what it comes down to is a acknowledgement by the Court of Appeal in that case that the incidental power embraces all of the duties, whether express or implied, of a statutory body or a local authority, and it's not confined to the express powers, but also applies to its incidental powers. And you see that not identified in those exact terms, but referred to in Lord Templeman's speech in Hazel and Hammersmith, which is, in fact, it's in two places in the bundle. Let's take it at tab 15, 1.5. And that's the case, of course, relating to swaps that were entered into by a local authority. And the relevant passage in the large page numbers is at 407. letter, just above the letter F, where Lord Templeman says, I agree with the Court of Appeal that in section 111 of the Local Government Act 72, the word functions embraces all the duties and powers of a local authority, the sum total of the activities Parliament has entrusted to it. Those activities are its functions. Accordingly, a local authority can do anything which is calculated to facilitate or is conducive or is incidental to the local authority's function of borrowing. So that's all functions, both express and implied.
Does he actually say that?
Well,
Is he making the point that it's not confined to duties? It's duties and powers. It's all its functions in that sense. But he doesn't actually address the express versus implied point, does he?
Well, yes, it isn't done in those, but the terminology is that section 111 relates to all the duties and powers. It's not said it relates to all the express duties and powers.
One has to read it in the context, doesn't one, of
Yes, I
what the issue
quite
was.
accept that.
It may be clearer if one were to see the passage which he is approving in the Court of Appeal, but I suspect there'll be the same ambiguity there. But we don't. Do we have the Court of Appeal judgment here?
Tab 13, and the relevant page, your ladyship and lordship will see it's 330. And in particular, over the page, 331, adjacent to the letter C.
Yes, I found the passage. He doesn't really advance the argument.
See, if you, forgive me for taking you back, Mr. Coppell, to page 407 in the House of Lords speech of Lord Templeman. If you go to the first half of that page, I've only reminded myself of this very quickly, so I'll stand corrected if I'm wrong. But essentially, this is I've always understood the legal position that the 19th century cases, Attorney General and Great Eastern Railway Company and so on, were regarded as being cases which established the proposition that a statutory corporation can have implied powers as well as express powers if they are reasonably incidental to its express powers. And then what he says, just before letter F, he says, Section 111 embodies these principles. And this may or may not be correct, but I've always understood that the common law doctrine of implied powers is generally regarded as being effectively codified into Section 111.
It may be that the two things overlap, but what we do say is that you may have, for example, implied powers because it hasn't been dealt with expressly in the statute, but you can see it by looking at the conspectus of legislation that it is implied that the body will do that. So, for example, you may have, let's say Parliament requires the Electoral Commission to come and attend to give evidence to a select committee to speak about the performance of its functions. There's no express power to go and attend, but there's an implied power on a body, which is a public body and accountable to Parliament, that it will do that. That's not incidental to any of its functions. That's an implied power as a body.
Well, I wonder, couldn't it be said to be incidental? After all, you, perhaps only under pressure from us, have been using implied/incidental in an earlier part of your submissions. I'd have thought that the two terms in their practical use are interchangeable in this context.
What would be said against that is that we have to identify the function in the statute, the express function in the statute, that requires us to attend. And what we say is, you won't find an express statement of obligation to attend.
But is that necessary? Wouldn't you just say, I forget how your example started, but that it is the function of this body to supervise the production of widgets, and attending a statutory committee, a parliamentary committee to answer questions about that is incidental to that function. It's just Occam's razor. It's a simpler way of analysing it, isn't it?
We would say that there's an implied power, and so that is what you, like duty indeed, that is what you do. And as part of that, there may be incidental powers that enable you to carry out the form. It may be that we're arguing, I think your lordship put it as arguing over nothing, and that's why I use the slash.
Yeah, well, that's where I am at the moment, so I don't promise to stay there.
Whether it's the implied or the implicit, we say it comes to the same thing. What is important, we say, is that we, the Electoral Commission, even if your ladyship and lordship find that there was no express power, which we say there was, had a incidental slash implied power to do what we did. And the real question in any ascertainment of an implied power or indeed power is to ask yourself, what are the functions of this body? What is it expressly charged with doing? And does what they did constitute a reasonable means of giving effect to those provisions? And what we say is that yes, it does, for all the reasons that I've mentioned in relation particularly to section 145. It is concerned, this body is very much concerned to ensure adherence to the restrictions and requirements, in this particular case, of the referendum regime by all participants, this referendum and in all later referendums. And that is what we do by publishing our report about how we go about the performance of our functions and letting the public know, letting would-be participants know.
Isn't that pretty well all you need to say, Mr. Cockle? Or are there great
Unless
chunks of
there
your
are other
submissions?
No, that is all I would wish to say. Very grateful.
Yes, Mr. Stranger.
Much obliged, my lord. Can I deal with a number of matters separately? And can I begin by making some references to section 145, schedule 19C, and the discussion which occurred as to the motor behind schedule 19C, to use the expression that was employed. First question, what does Mr. Cockle want to do? Answer, he wants to publish a report referencing schedule 19C matters. There's no doubt at all about that. Does he say that it's incidental to schedule 19C to publish a report about schedule 19C matters other than in the way provided for by schedule 19C? He doesn't appear to do so.
What if we think that's the right approach?
I beg your pardon?
What if we think that's the right approach?
Oh, well then, if your lordships think that's the right approach, one needs to reflect upon the terms of schedule 19C and to contemplate that one can do that which is incidental to the functions which arise under schedule 19C. And incidentally, if I can, the driver in connection with schedule 19C and schedule 19B and 146 and 147 is nothing to do with section 145 at all, but it arises because, as the court will remember, the Interpretation Act 1978 provides that when a duty is given or a power provided, it is to be performed from time to time as occasion demands. I believe from recollection it's section 12 of the Interpretation Act, but that is what the Interpretation Act says. And so when you have a schedule such as 19C, which says that the Commission can do these matters, or 19B, it does them as occasion demands. It is not driven by section 145, and indeed, for reasons which I'll come to, couldn't be driven by section 145. But I step back to your Lordship's question about, well, why can't it come under Schedule 19C as an incident of Schedule 19C? The answer to that is it has truly to be incidental to 19C, and it is accepted for present purposes that an incident of Schedule 19C may be to post on the website the notice, may be to post on the website all 4 notices together, to deal with my lady's point, but it is not incidental to Schedule 19C to post on the website the notices and, or in substitution for the notices, a completely different report which doesn't embrace what is required by Schedule 19C, as we've seen earlier. And for my learned friend to say that a recipient should follow a paper chase going on screen to get to the last page in the appendix and to get more or less to the last line and then press on it and no doubt to go through some other pages is unrealistic in my respectful submission, because we have to contemplate this as a document, and as a document it was given as such to the BBC, to the Times and so forth, and it doesn't contain what is in Schedule 19C as a requirement. So it wasn't an incident of Schedule 19C, and the fact that one can do as an incident of 19C the matter of here is the notice reveals by itself that it can't be. Now I appreciate my lady's observation to the effect, well, here are 4 and let's put them as 1 because isn't that more convenient to do so? Well,
I'm not sure convenient would be quite the word.
Very well. I don't want to use any word which suggests a manner of thought or anything of that sort, but your ladyship contemplated a report to deal with all 4. My lady, with greatest respect, that cannot be the position in terms of something which is ancillary to Schedule 19C, which provides for individual notices individually with individual rights of appeal. It just opens up the problems of you've now got 4 in the notice, 1 appeals, 1 doesn't, 1 abandons the appeal, 1 succeeds in part in the appeal, and so forth. You've got 1 report dealing with them all in circumstances where, if nothing else has been revealed by this case, it's the fact that chasing documents down through a website is not necessarily conducive to producing the clearest possible document by way of response. So one has that problem, but it's overcome, as I say, by virtue of the fact that if it's an incident to be able to say, we have issued these notices, here they are, why do you need the report? You simply don't. And therefore it's nothing incidental to Schedule 19C because it's got no relationship with Schedule 19C. The incidental provision, the paragraph 2 in Schedule 1, is designed to cover a vast range of matters, from enabling the Election Commission to go out, the Electoral Commission to go out and buy a stapler, to doing the sorts of things that we've been talking about in terms of maintaining a website and putting things onto a website. But it's that ancillary nature which has got to be shown, and one can't see through this report an ancillary nature to Schedule 19C. Now, can I then go to section 145, upon which some time was expressed? And the debate was between, this is covering a contemporaneous circumstance, or this is covering my learned friend's position, a position in futurity. Is it, in other words, the monitoring as the referee monitors the match for the 90 minutes or the 80 minutes of the match? You then may have 2 months later a commission of inquiry determining whether or not a foul was committed and the player ought to be suspended. Or is the exercise one where it's not a refereeing of the match, but it's something which extends over the future, so that the referee can then say 2 months later what the commission of inquiry has been set up to find out about the match. 2 points first. 1 point first. If monitoring is, as a matter of ordinary approach, consistent with contemporaneous position, and then the balance of section 145, the character of the language which you've got, and I want to get right in making the observation, namely, take all reasonable steps to secure compliance with, must surely also be contemporaneous, because it's referring to the same circumstance. And if I'm right, as far as the Interpretation Act is concerned, so that the motor for Schedule 19B and 19C are automatically present, you don't need any motor for those provisions, because you already have those through the Interpretation Act. But then if one just looks, if you don't mind, at the only conceivable candidate within 145, it is 1A2 Part 7. And just go back, please, to what we said in our skeleton argument at paragraphs 46 and 47. 153 and 154. And what has happened here in these paragraphs is an analysis, and you'll be able to go through subsequently each of these sections to see that we've got it right. Setting out the referendums to which it applies, 101 to 104, precise timetable, and also geographical limits, because this Act could cover one for Scotland or some different part of the United Kingdom alone. Defines the temporal referendum period, which we know about. And then the provisions of Part 7 are all referable to referendums as so understood. 111, financial limits, referable to the period, as are the restrictions. Returns had to be made relating to the referendum period and within 6 months of the end of the period. And so I readily accept that you could monitor and take steps to secure compliance with returns being made. So it may well be a reasonable step for the Electoral Commission to engage with those who participated, and please send them a reminder or publish in the newspapers a reminder to do this. So that's for 6 months at the end of the time, with public inspection thereafter for a limited period of time. And Part 7 also includes provision as to chief counting officers and the ability on the part of the Secretary of State 128 and 129. So all matters which you would be looking at, monitoring to see what is happening, and taking reasonable steps, which may embrace, as I've said, for returns to be made, a reasonable step taking provision to secure that people know and are reminded they've got to do this. Because don't forget that as far as this referendum is concerned, there was a potential infinite number of participants in this referendum, and that those participants could range from, as it happened, an organisation such as Believe, whose founding spirit was a 22-year-old student from Brighton University, to a 90-year-old who also was passionate one way or another about this matter. So you've got all these people embraced within this, and therefore sensible to be able to take reasonable steps to secure compliance, to have some mechanism in place to tell them that you don't need it for anything else, because you already have the ability to carry out the sanctions functions and so forth, otherwise, because you've got the ability to do that. So it's not section 145, and it's not schedule 19C. It's then necessary for me to say just a word or two about some other matters. First, the Liverpool case. What's important about the Liverpool case is not the observation that was passed between my Lord Justice Singh and my learned friend, but what's important about it is section 142 of the Local Government Act, which enabled properly Mr. Fordham to say that they could issue a press release if they were doing something consistent with the statutory regime. As far as the Taylor case is concerned, this was the Director General of the Office of Fair Trading, and under the Fair Trading Act, and I think it's section 1, I can send it across if needs be, the Director General was an officer appointed by the Secretary of State. Not a corporation created as here by the 2000 Act, and therefore subject to all the rules about can do this but can't do what you're not empowered to do. Out with that altogether. The Charity Commission case I see it being pointed out that in any event political parties are not able to sue for defamation, just as Goldsmith and Bagat, 1998, Queen's Bench 459, I'm being told. But
What's the relevance of that?
well, I think it just closes off one particular point my learned friend was saying that because of defamation there might be some provision obtained. But the real point is that in the Director General case, this was not a corporation. The Charity Commission case, please see the bundle of authorities at page 534, where Lord Mance sets out, flag 20, the powers of the Charities Commission, which are very extensive indeed, and include towards the foot of the page the obtaining, evaluating and disseminating information in connection with the performance of any of the Commission's functions. So it had remarkably broad powers, and has remarkably broad powers, about the dissemination of information. So it may well be that there are political imperatives suggesting that openness is a good thing, but there's nothing which undermines the proposition that if you are a corporate body, you are stuck with the ultra vires rule. And then finally, as far as that is concerned, on the Freedom of Information Act, this is a matter which sort of passes all understanding in some respects, with greatest respect to my learned friend, but it is quite plainly an attempt to say that you can have a body which is not empowered to do anything, where on the conventional basis discussed in innumerable cases, enabling you to come to court and say this is an archetypal judicial review case where I can point to an error of law, you don't have the power to do this. You are confronted by no, because of section 19 of the Freedom of Information Act, which says you must have a scheme, therefore you must have a scheme, and that scheme enables you to be able to do that which otherwise you are unempowered to do. In my respectful submission, it simply can't be the case that such is the case. And it's interesting to note that the provisions about local authority publicity, about what can and can't be secured out of local authorities, have been in place for a number of years, but have continued to be amended and have been amended post the Freedom of Information Act 2000. Why, one might suppose, would that be either necessary or desirable if the Freedom of Information Act effectively provided that, so to speak, everything must be exposed and we can do whatever we want, and therefore it's simply a matter of the information scheme. Incidental point, my learned friend said that the Grimes appeal was unique to Mr. Grimes and the matters within it. That is not so, far otherwise. We had 5 days, and you will see the grounds of appeal, and they embrace the whole range of material, and you've got...
I don't think he meant all the points raised, that he meant the basis on which Judge Dyke decided it.
Oh, well, yes, but even the basis that he decided it, because he obviously took some shortcuts following the established rule that you don't decide more than you have to decide. But even in what he indicated, for example, at the end, where he said that even if he'd been against me for Mr. Grimes, he would still have thought that the penalty was excessive. The discussion about the penalty, which had been promoted by Sir James Eadie, was to the effect that because this was all part and parcel of a common plan, which he was unable to identify, Sir James was unable to identify as is given in evidence, therefore the penalty should be higher. So it is simply not the case that one is able to say that one has this unique position with regards to Mr. Grimes. That's not so at all. So we get driven back, in my respectful submission, ultimately to the essence of the case that I started with today. And we have that double-handed essence, if I may respectfully say so. Where is this power for this separate, and remember that word separate, qualifying the report, separate report from the notices? Where is the power to make and publicise this report? And you just can't find it because it can't be incidental, because it's not a Schedule 19C matter. And where do we see it in the code for Schedule 19C? We just don't see it at all, and the code is comprehensive. And why wouldn't the code be comprehensive? Because it's designed to secure fairness between the parties, because one has to remember there are parties here, and it's all fine and large to say that the public ought to know X, Y, and Z. There are parties on both sides of this, and one seeking to secure fairness to them. And we know, incontrovertibly know, that the report has and continues to have a hugely prejudicial effect in circumstances where we can say with certainty that just as with an election, just as with a referendum, the parliamentary intention is quite clear that you shut down, after a period of time, a debate about what has gone on before procedurally with regard either to the election or to the referendum. The election, you've got 21 days, incapable of extension of petitioning. Referendum, you had 6 weeks, incapable of extension for judicial review. Destroy everything after a year, destroy returns after 2 years. You bring it to an end, and as the courts have said, the purpose of bringing it to an end is so that you don't have, to a large degree, this constant retrospective, but rather focus upon issues which might be thought to be of more materiality than these issues which arose in 2016 and then came to be considered in reports in this report in 2018 in supplement to the notices which were capable of being appealed. My lords, I've gone past 4:15, for which I apologise. Unless there's anything else I'm reminded of or the court wishes to raise, that's all I wanted to say.
Who says there is something else?
Yes. Yes, it was just the point, if I can just finish on this, it was not correct to say this is a copy and paste exercise between the notices and the report. Look at them again and you'll see that the structure of them is entirely different and the content is not repeated or pasted across from one to the other.
Thank you very much.
Much obliged.
Well, as you will of course appreciate, we aren't going to give our judgments straight away. We will follow the normal procedure under which copies will be circulated in draft to council, both so that we can have any typographical or other minor factual errors drawn to our attention, but also so the parties can, if possible, agree the terms of any consequential orders, and if they can't, can submit short written submissions about the points of dispute in advance of the hand-down date. There will then be a hand-down of the judgments in final form, at which the parties need not attend. Thank you all very much.
May I be impertinent enough to ask one question, my lord, which is this. Would the court wish me to send through copies of the relevant section from the Interpretation Act and from the Fair Trading Act to verify the points I've made in oral argument?
Well, I think that would be sensible, just to close off those points. It does mean that Mr. Coppell will have the opportunity to comment on what you send in, but I'm sure he will use a wise restraint as to whether or not it's necessary to do so. But if you could do that as soon as possible.
Yes, of course.
Thank you.
All right.
I'm not going to be in here very long, so if you cut, I might have to take stuff outside.
I'm not going to be very long.
Okay, I'll be locking the doors, okay.